Dear students, viewers and the subscribers, welcome to the IAS Mentor. This will be our episode number 8 in the series Indian Polity Current Affairs for Prelims 2025. The objective of this particular series is to cover the most probable topics. So the idea is that we are going to cover almost around 50 topics. I think by this episode 8, we will be covering around 40 topics. And the last episode that I will do is on miscellaneous topics. So there I will cover roughly around 10 topics. So almost 50 topics that you have picked, which touched upon the different parts of the polity syllabus, right from fundamental rights to the executives, to the legislature, to the center-state relationship, to the constitutional bodies, to the statutory bodies. Today we are going to touch upon another important area, that is elections and the Representation of People Act. UPSC of late has been asking one question from this particular topic also, and mostly related to the current issues. So let us cover few topics, but it is extremely relevant for your examination. So students who are appearing for Prelims 2025, I would suggest that you watch through this current affairs series. It is not going to take you much time. It will hardly take you around 4 to 5 hours, where 50 topics will be covered. For the students preparing for the planning for the Prelims 2026, you can also watch it. But before watching this current affairs series, I would recommend you to watch the Indian polity series, so that first you have the basic knowledge, then you can relate that to the current affairs. In addition to this, we are also doing a polity series with regard to the previous year questions. The last 15 years of previous year questions are being covered. So that's also very useful for the students appearing for Prelims 2025. So overall, the objective is that we are planning to help the students to get at least 80% of the questions from the subject polity in the Prelims 2025. Now these are not the only series. Moving forward, we will do a series on the other areas also. So but all the series will roll out from say a week time. So please keep watching and subscribe yourself to the channel, the IAS Mentor, for the latest videos, which is going to be extremely useful to the students appearing for the civil service examination and also to the other competitive examination. All right. So with that, I'll go to the first topic in the episode number 8. So where I want to talk about the silence period during elections. Now, what is the silence period and why it was highlighted in the news? Last year, before the election, there was a controversy that the Prime Minister of India has gone for what is called as public meditation. And this happened during the silence period, in fact, and hence there was criticism against the Prime Minister engaging in public meditation, and that is also relayed in TVs and other medias. So therefore, experts also criticized that it would go against what is called as a silence period, and they also said that it is in violation of both the Model Code of Conduct and the Representation of People Act 1951. Now therefore, in this context, at least as a student preparing for UPSC examination, you should know as to what is a silence period. Now what is a silence period? As per the Representation of People Act, if you see which section in the Representation of People Act 1951 deals about what is called as a silence period, is section 126 of the Representation of People Act. In fact, there are two Representation of People Act. One is the Representation of People Act 1950, another is the Representation of People Act 1951. So which law talks about the silence period? It is the Representation of People Act 1951 under section 126. So what does it mean by the silence period under the Representation of People Act 126? The silence period is basically a period 48 hours prior to the conclusion of the polls in a particular area. Suppose the polls are concluding at 6 p.m. on a given day, and from 6 p.m. if you go back 48 hours, that's basically what is called as a silence period. So what do you have to do during the silence period? The basic thing that has to be done during the silence period is that no form of election propaganda has to be done. So that would invariably give benefit to a particular political party or a candidate. That's basically what is the law under the Representation of People Act. And to that extent, it is also covered under the Model Code of Conduct, as long as the Model Code of Conduct is in force. So if you look into the section 126, further how it explains it, section 126 of the Representation of People Act, inter alia, among other things, prohibits election campaign, activities through public meetings, processions, etc., and displaying of election matter by means of television or other similar apparatus. television or other similar apparatus is also including what is called as a social media. In fact, today the social media has come to play a very important role with regard to the elections in our country and the way that they can polarize and reach out to the voters. So therefore, the silence period would also cover what is called as a social media 48 hours before the conclusion of the polls. Election matter under the Representation of People Act 1951, that is under section 126 of the Representation of People Act, refers to any matter intended or calculated to influence or affect the results of any elections. So therefore, it can be anything that would affect the outcome of the elections. It can be seen as what is called as election matter. At least try to remember the section which deals with the silence period in the Representation of People Act 1951. And what is a silence period? 48 hours prior to the conclusion of the polls is usually considered to be what is called as a silence period in elections. So this is again very important in my opinion. You should know as to what is a silence period. But however, I would say this topic is a very, very important topic and you can definitely expect a question in your prelims examination. And what is this particular topic? So just give me a moment. So this topic is very, very important topic. So let me discuss you as to what this particular topic is all about. If you look into this particular topic, what this particular topic is talking about, why can an accused person in prison contest polls but not vote? So it is talking about an accused person. An accused person is someone who is still not yet proved guilty in a court of law. He is still an accused. That means a trial is still happening against an accused person. So he may be in jail, he may be in police custody, but he is still not yet convicted. So therefore the question is, why an accused person in prison or for that matter any of the other places contest polls but not vote? That means you should understand as to what is the position of law today in our country. Is can an accused person contest the polls? Yes, the accused person is allowed to contest the polls. But can an accused person will have the right to vote? No, the accused person will not have the right to vote. What are the laws relating to that? Now, why it is relevant? Why it was in the newspaper? In which context? There was a public interest litigation that was filed in the Supreme Court. And what is this public interest litigation? This public interest litigation in its petition raised the question that whoever is convicted in a court of law should be completely debarred from contesting the election in the future. It is not only that they are disqualified for a certain number of years, which is the position of the law presently, but the petition is expecting a ruling from the Supreme Court of India that person who are convicted in a court of law and therefore disqualified from contesting election not only for a fixed term but permanently. Now this matter has come up before the Supreme Court hearing, and that's why we have to understand as to what is the position of law with regard to right to vote and with regard to what is called as right to contest election. So now let us try to understand both the things. So first let us try to understand as to what is the provision of the law with regard to disqualification when it comes to what is called as contesting election. Then we will discuss about what is called as the right to vote. So if you look into the Representation of People Act, which is considered to be the election laws in our country, the disqualification provisions is dealt under what is called as a Representation of People Act 1951. In fact, there are certain grounds for disqualification to contest election which is given in the constitution itself, but more and more grounds are given in what is called as a Representation of People Act 1951. Now in fact the Representation of People Act 1951 in section 8, to be very specific, section 8 of the Representation of People Act 1951 makes it very clear that a member or a candidate might be disqualified from contesting election on the grounds of what is called as conviction in a court of law. If a person is convicted in a court of law, then they are disqualified from contesting election, not otherwise. This is very, very important. If suppose merely a charge is there, merely a charge is framed against the individual and the trial is still happening in a court of law, that does not disqualify an individual from contesting election. When an individual is disqualified from contesting election, when he is convicted in a court of law, conviction for certain offences. Now there are two types of convictions. In fact, there are certain types of conviction where a mere conviction is sufficient enough for their disqualification, which is given in the Representation of People Act itself. Say for example, conviction under the Civil Rights Act, conviction under certain offences like Prevention of Corruption Act, conviction under certain offences like serious criminal offences. Those offences are given in the Representation of People Act. So therefore, in certain cases, mere conviction is sufficient. So mere conviction, when I say mere conviction, the conviction can be of any term. That's what the understanding you should have. So any term conviction, sometimes the conviction can even be a fine. So mere conviction is sufficient enough, and even if there is a mere conviction, then they are disqualified from contesting election, and they are also disqualified from another 6 years after the release once their conviction period is over. So plus they will be disqualified for another 6 years. That means if an individual is convicted under the Prevention of Corruption Act, or if the individual is convicted under the Civil Rights Act, let us assume they are convicted for 1 year. So anyways, 1 year they cannot contest election, and after the release from the prison, again for another 6 years they cannot contest election. So therefore, in this case, 7 years of disqualification. But however, there is another form of disqualification for conviction of for offences, certain offences, except for those offences which is specifically mentioned in the Representation of People Act. In case of conviction for other offences, the minimum conviction period has to be 2 years. Only when the minimum conviction period is for 2 years, then they are disqualified. And how long they are disqualified? They are disqualified for another 6 years, depending upon whatever is a conviction term. So when the conviction will when the disqualification will kick in, only when they are convicted for 2 years. And suppose it is 4 years, then 4 years will not be able to contest election, and after the release from the jail, another 6 years. So this is what you will have to understand. So therefore, one thing has to be very clear in your mind, that today the Representation of People Act 1951 makes it very clear that when a candidate shall be disqualified from contesting election, only if he is convicted in a court of law. And what is a petition right now asking? The petition is saying that they shall be disqualified permanently, which is not the law saying. So the petition is asking for it. So that is the reason that this was in the newspaper. Okay, a person is disqualified for contesting election for a certain number of years, that is convicted for 2 years, therefore disqualified for another 6 years, therefore a total disqualification of 8 years. Can he contest election after that? The law does not prohibit him from contesting the election. Is there any relaxation that can be given by any of the authority with regard to the disqualification period? Yes, that is also there. So who has the authority to give any relaxation in this particular matter? Okay, so even before going to that, let me just discuss. Okay, in case of conviction, an individual is convicted for 6 years. Now let us assume, is it possible for him to make an appeal in the higher court? Yes. Suppose if the conviction happens in a subordinate court, in a district court, the convicted candidate or the convicted person is very well free to make an appeal in what is called as the high court. And the high court, if they stay the conviction, this is what is very important, if they stay the conviction, then the individual is free to contest the election. But if the high court does not stay the conviction, then the individual cannot contest the election, still his disqualification would continue. So what does it mean by staying the condition? Suppose let us assume a member is there, a candidate is there, and that candidate is convicted for 2 years. Let us assume he is convicted for 2 years on defamation case, criminal defamation. And because he is convicted for 2 years on criminal defamation, minimum conviction is 2 years, so therefore he can be disqualified. So therefore in this case, the individual is disqualified from contesting election for 2 years till the time he is released, and then he is also disqualified for another 6 years because he is satisfying the minimum conviction period of 2 years. Suppose let the individual is convicted in a district court, so therefore the individual is making an appeal in the high court. When the individual goes to the high court, if the high court stays the conviction order which is passed by the lower court, then in this particular case the individual is free to contest the election till the time the matter is decided by the high court. Now staying the conviction means, as per the legal standing, staying means the individual is not yet proven guilty in a court of law because the high court has stayed the order that is passed by the lower court. But instead of staying the conviction, the high court is only granting the bail. So granting bail versus granting stay, there are two different things. Granting bail is where the legal position is still the individual is considered to be convicted. It is only that his imprisonment is suspended temporarily. That is basically what is called as bail, pending the appeal in the higher court. But whereas staying the conviction means the legal position is he is not yet considered to be guilty because that is what is under consideration in the high court. So therefore, when an individual will be eligible to contest election, even if he is found guilty by a lower court, if the conviction is stayed by the higher court. So if the conviction is stayed by the higher court, the individual is still eligible to contest election. So therefore, try to understand, when an individual is disqualified from contesting the election, Then individual is disqualified from contesting election only when he is convicted in a court of law. And there are certain offences mere conviction is sufficient enough. There are certain offences where the conviction should be a minimum of 2 years period. But however, can this disqualification be reduced by any of the authority as per the legal position in our country? Yes, that can also be done. The Election Commission of India is authority, and the Election Commission of India is given the power under section 11 of the Representation of People Act. Under section 11 of the Representation of People Act 1951, the disqualification period of any of the person can be removed or it can be reduced by the Election Commission of India for the reason given in writing. That is again very, very important. Suppose an individual is convicted for 2 years and therefore he is also disqualified for another 6 years after the release from the prison. Can this disqualification period of 6 years after the release from the prison, can it be reduced to 4 years? Can it be reduced to 3 years? Yes, it can be done by whom? It can be done by the Election Commission of India. So you can remember this particular area also. This is again very, very important. So therefore, till this point of time, what you are trying to understand is if a person is convicted in a court of law, therefore he is disqualified from contesting election. But let us assume an individual is not convicted in a court of law. If an individual is not convicted in a court of law, can he contest election? Yes, very much he can contest election. Even if an individual is in what is called as jail. Suppose let us assume an individual is not yet convicted in a court of law, but he is detained by the police for the investigation and therefore he is in jail. So will he be able to contest the election as per the law? Yes, nothing in the law will prevent him from contesting the election. But can he vote in the election is a question mark when he is in police custody, when he is in the lawful custody of the police or when he is in jail. That is, as an accused he is in jail or he is in police custody. The law is very clear. If a person is convicted in a court of law, he is disqualified from contesting election. But however, unless until he is convicted in a court of law, he can contest the election. But however, if a person is in the lawful custody of the police or is in jail as an accused, he will not be eligible to vote. So, but however, you'll have to understand, although he is not eligible to vote, he can still contest the election unless and until he is convicted in a court of law. This is what is very, very important. And what is a provision of the law which provides for this? It is section 62 clause 5 of the Representation of People Act. Now, what is section 62 clause 5 of the Representation of People Act is saying? Section 62 clause 5 of the Representation of People Act is saying if any person is in the lawful custody of the police or someone as an accused is in jail, he is an accused. The key word here is accused. That means accused is someone on whom a charge is framed. He is still not convicted in a court of law. So anyone who is in the lawful custody or in jail, but he is still an accused. In this particular case, they will not have the right to vote because the law, the Representation of People Act as per section 62 clause 5 clearly states someone is detained by the police or in the lawful custody of the police or in jail as an accused, their right to vote stands suspended. They will not have the right to vote. The only exception here is if they are detained as a part of the preventive detention, not in case of punitive detention. So in case of preventive detention, they will have the right to vote. Otherwise, they will not have the right to vote. So excluding the preventive detention, a person in police custody will not have the right to vote. But can he contest the election? Yes, they can very well contest the election. So now you can ask me a question that, sir, they are not having the right to vote, but how they can contest the election? Because the law is quite clear, when they are in the lawful custody of the police as an accused, the right to vote is only temporarily suspended. Though their right to vote is temporarily suspended, their name continues to be there in the electoral roll. Because one of the conditions to contest the election is that their name should be there in the electoral roll. So therefore, when they are an accused and therefore they are in the lawful custody of the police, though their right to vote is temporarily suspended, their name continues to be there in the electoral roll. And because their name continues to be there in the electoral roll, they can contest in the election, but however, their right to vote stands suspended. So this is very, very important. That is why you should carefully understand, how do you think a person in jail as an accused or in the police custody as an accused, though he is not eligible to vote, but still he is allowed to contest election, because during the time, because of section 62 clause 5, the right to vote is only temporarily suspended, but doesn't mean that the name of the candidate is removed from the electoral roll. So this is basically what you will have to understand. So this should be very, very clear. So can a person who is an accused and placed in jail or in police custody, will he have the right to vote? No, he will not have the right to vote. But can he contest election? Yes, he can contest election unless and until he is convicted in a court of law. So this has to be very, very clear. I think this year they can definitely ask a question from this particular area. So please come to the topic number 3. In fact, the Election Commission of India avoids the law ministry not to deregister inactive parties. In fact, this is one of the long pending reforms that the Election Commission of India has been asking for. And what they are asking for, that they should be given the power to what is called as deregister the political parties. In fact, many students have a confusion between deregistering a political party and derecognizing a political party. These two are completely different things. So what is the context in which this news is important? The context is recently the Election Commission of India has written to the Law Ministry saying that there are a lot of registered parties which has been very inactive for a long period of time. In fact, there are thousands of registered parties which has been inactive for a long period of time. And now the Election Commission of India has written to the Law Commission saying that once they are registered as a political party, they do have a lot of benefits under the number of laws. One such important benefit is that they are exempted from the income tax as per the Income Tax Act. Certain income tax benefits are given. So that is what is the benefit that may be given to the political parties. So the Election Commission is of the opinion, so many parties do register just to get these benefits rather than an intention of fighting elections in an electoral democracy. So therefore, we should also be given the power to deregister the political parties. But now what is the position of the law in our country? There is a specific provision under the Representation of People Act 1951, and that section is section 29A of the Representation of People Act. Section 29A of the Representation of People Act presently gives the Election Commission of India only the power to register the political parties and do not have the power to deregister the political parties. Now, once the Election Commission of India register a political party, then they will have all the benefits of a political party, as I already said, including the tax exemptions they may get from the Income Tax Act. But however, these things are misused today in the opinion of the Election Commission. That's why they have returned to the Law Commission of India. So probably to amend the Representation of People Act 1951, also give them the power to deregister the political parties. Once they are deregistered as a political party, then they no longer enjoy the status of a political party, and they may not get the benefits that are conferred upon the political parties, which include that they may contest election, they may have access to the electoral rolls and all those things, including the IT exemptions. But however, there is a distinction between what is called as derecognition and deregistering a political party. Now, what is the difference between deregistration and derecognition of a political party? Now, deregistration means they are losing the legal status of a political party. But derecognition means it is not that they are losing the recognition of a political party, but maybe they are derecognized either as a national party or a state party. Now, please try to understand, depending upon the performance of the political parties in the election, they may be recognized as what is called as national level parties or state level parties. So, derecognition is only downgrading their status either from a national party to a state party or a state party as not being recognized as a state level party based on their performance. While the Election Commission of India today have the power to derecognize the political parties as a national party or a state party based on the Election Symbols Order 1968. So therefore, there is a provision also there, which is the election symbols reservation allotment order 1968. So under this they have the power to derecognize, but they do not have the power to deregister. So therefore, be very clear about it. Deregister means taking away the legal status as a political party. Derecognition is only that their status is downgraded as a national party to a state party or a state party not even being a state party. But however, in derecognition, they still continue to be a political party. Their legal status is still a political party. So as of now, the Election Commission of India is not directly having this power under the Representation of People Act 1951. But in extreme cases, the Election Commission of India based on its power under Article 324, they can also deregister the parties by moving to the court. But however, it is not there explicitly in the Representation of People Act 1951, and that is why the Election Commission of India has returned to the Law Ministry to amend the Representation of People Act and to deregister the political parties. Okay, so again, very important, understanding the difference between what is called as deregister and derecognition of political parties. So this is a very important topic. So please come to the next topic, that is National Voters Day, a very simple topic. So this National Voters Day is recognized and followed in our country to bring awareness about elections in our country, and which is considered to be the National Voters Day. 25th of January is celebrated as the National Voters Day, and in fact recently we have celebrated the 15th National Voters Day. So this is again very important, so you may remember the date. And maybe the theme of this year, National Voters Day. So what is the theme of this year? Nothing like voting and I vote for sure. So this was the theme of the National Voters Day today. And in addition to that, during this year, during the National Voters Day this year, that a couple of things have happened. One is a documentary series, India Decides, was released by the President of India. And then there was one more thing is, book, a publication by the Election Commission of India, Belief in the Ballot, Human Stories Shaping India's 2024 Election. Now both the things are aimed at promoting the democratic values and awareness about elections, and also how historically the elections have evolved in our country. So this is what has been focused in these things. So basically you may remember the date here and probably the theme. So these two things can be a relevant area. Sometimes these minute facts may also be asked in the examination. So the next topic related to the elections and the Representation of People Act. Recently, two bills has been introduced in the Parliament. So despite a lot of opposition from the opposition parties, and the two bills are related to bringing in what is called as simultaneous elections in our country, which has been in discussion for the last 3-4 years. And what was a bill that was introduced? One is the 129th Constitutional Amendment Bill, trying to make changes in the constitution in order to ensure what is called as simultaneous election. And other was an ordinary bill to help the simultaneous elections happening in our country. So basically what is simultaneous election? So today simultaneous election means conducting elections simultaneously to the Lok Sabha, to all the state legislature, and also to the Union Territory of Delhi, Puducherry and Jammu and Kashmir. So all these elections have to happen simultaneously. That's the idea. So presently these elections are not happening simultaneously. So the people who are in favor of simultaneous elections, they say that it can reduce policy paralysis, it can reduce the cost of expenditure, it can provide better governance. But people who are against this, they are of the idea that it is anti-democratic, anti-federalism, it does violate certain basic structures in the constitution. So though we are not here to fully analyze these areas, which may be relevant for your mains, but you should be aware of certain facts when you go to the preliminary examination. Say for example, they can ask you which constitutional amendment bill introduced in the Parliament related to the simultaneous election, that is 129th Constitutional Amendment Bill. So sometimes they may ask you some of the provisions of this particular bill also. So let us try to quickly understand as to what are the major provisions of this particular bill that was part of the bill to ensure what is called as simultaneous election. In fact, it tried to amend a number of provisions, but some important provisions of this bill. One is it tried to insert a new article, that is the 129th Constitutional Amendment Bill. It tried to introduce a new article, that is Article 82A, that would enable simultaneous elections, because you will have to make changes in the constitution that would enable what is called as simultaneous elections. And apart from that, there has to be some way of synchronization between the term of Lok Sabha and the term of various state legislative assemblies. So therefore, the term of these things are covered under Article 83 of the Constitution and Article 72. Article 83 in case of the duration of Lok Sabha, and Article 172 in case of duration of the state legislature. So therefore, to synchronize them, some amendments are also to be added here. And apart from that, Article 327 gives a power to the Parliament to make laws with regard to the election to the Parliament and state legislature. So they wanted to bring in some changes in this respective articles as well. So these are the major articles that may go for a change if the 129th Constitutional Amendment Bill is passed. And remember, the 129th Constitutional Amendment Act is trying to alter the federal provisions in the Constitution. So whenever a federal provision in the Constitution is to be altered, it not only requires a special majority in the parliament, but it also need to be ratified by not less than half of the state legislature. So therefore, it shall be ratified by not less than half of the state legislature as well if it is to become an act. And subsequently, yes, it has to be given assent by the president. So we'll have to wait and see. So presently, the bill is referred to the joint committee in the parliament. So let us wait and see what kind of development is happening in this bill introduced to bring in simultaneous election. In addition to that, I said that not only the 129th Constitutional Amendment Bill is introduced, in addition to that, an ordinary bill has also been introduced in order to ensure what is called as simultaneous election. But this ordinary bill is trying to amend the laws related to the union territories in our country. It is trying to amend the National Capital Territory of Delhi Act, the Government of Puducherry Act, and the Jammu and Kashmir Reorganization Act. So based on which the union territories are provided the legislative bodies. So therefore, an amendment is also required in these areas, but this is a simple act of parliament. And the simple act of parliament may be passed with what is called as a simple majority. It does not require the same majority as that of the 129th Constitutional Amendment Bill. So again, it is a long way to go. So let us wait and see as to what kind of changes are happening, whether these bills are passed. It is for the parliament to decide in the coming days. And I am sure that there is going to be quite a bit of opposition for all these bills. So with that, we are coming to the end of this particular episode 8 as well, which we have dealt with elections and the representation of people. Again, very, very important. We have touched upon topics like will it be possible for a convicted person to contest elections? Will it be possible for a person in police custody to vote in the elections? So these are all important area where UPSC can focus upon, including the silence period, simultaneous elections, and all those things. If you have any doubts or queries, you can reach out to me either through my Instagram account or through my Telegram channel. If you like this video, please share it with your friends, and I'm quite sure it is going to help thousands and thousands of students in the coming years preparing for the UPSC examination. You can think me as your friend, guide, or a mentor who can help out in clearing this examination. So if you have any queries, you can reach out to me. Thank you very much. All the very best.